Hey, so a lot of people are spazzing out about WWE. Again, obviously, enforcing their intellectual property rights. So we're going to talk today about intellectual property and why WWE probably did these things. Again, for starters, out the gate, I am not a lawyer, but I am a guy who, common sense is a real thing. So let's discuss this. We're going to discuss it from a lot of the things that I've saw so far. I'm not going to be, let's be honest, I'm not going to be 100% correct on a lot of these things, but I should be in the same ballpark as the understanding of WWE. And I do have a bit of a cold, so if I sound nasally or somewhat off, then that would explain that. So first, let's go through the contracts. So somebody smartly posted the contracts of WWE's intellectual property. But first, before we start talking about the contracts, let's go through what intellectual property actually is. Okay, so because a lot of people might not know what that means. So this is from the Stanford University Libraries. This is the overview of intellectual property laws. I will put this in the description so people can see it. And I'll just be reading reading this, and then we'll read the WWE contracts, and then we'll go from there. Okay. So, overview of intellectual property laws. A wide body of federal and state laws protects creative property such as writing, music, drawings, paintings, photography, and films. Collectively, this body of law is called intellectual property law, which includes copyright, trademark, and patent laws, each applicable in various situations, with each with its own set of technical rules. When obtaining permission to use creative works, you're concerned primarily with copyright law. However, trademarks, trade secrets, and privacy rights sometimes come into play when permission to use certain types of works is sought. Below is a summary of the various types of intellectual property laws that are relevant to the permissions process. 1. Copyright. Federal copyright law protects original creative works such as paintings, writing, architecture, movies, software, photos, dance, and music. A work must meet certain minimum requirements to qualify for copyright protection. The length of the protection also varies depending on when the work was created or first published. 2. Trademark. Brand names such as Nike and Apple, as well as logos, slogans, and other devices that identify and distinguish products and services, are protected under federal and state trademark laws. Unlike copyright laws, trademark receive different degrees of protection depending on numerous variables, including the consumer awareness of the trademark, the type of service and product it identifies, and the geographic area in which the trademark is used. Number 3, right of publicity. A patchwork of state laws known as the right of publicity protects the image and name of a person. These laws protect against the unauthorized use of a person's name or image for commercial purposes. For example, the use of your picture on a box of cereal. The extent of this protection varies from state to state. Number 4, trade secrets. State and federal trade secret laws protect sensitive business information. An example of a trade secret would be confidential marketing plan for the introduction of a new software product or the secret recipe for a brand of salsa. The extent of trade secret protection depends on whether the information gives the business an advantage over competitors, is kept a secret, and is not known by competitors. Next, the right of privacy. Although not part of intellectual property laws, state laws preserve the right of all people to be left alone. Invasion of privacy occurs when someone publishes or publicly exploits information about another person's private affairs. Invasion of privacy laws prevent you from intruding on, exposing private facts about, or falsely portraying someone. The extent of this protection may vary if the subject is a public figure, for example, a celebrity or a politician. Okay, so that's intellectual property laws, okay? So now we're going to go through the WWE contracts that has been posted. It's been posted everywhere. I guess this is an example of something that Stephanie McMahon posted. It is going to be extensive. Okay, it is a lot of legalese, and it's going to sound like a lot. Okay, but we're going to go through this real quick. So I guess this is the third clause of the contract is just highlighted. Let's see, 3.1. All service marks, trademarks, and other distinctive identifying indicia used by wrestler prior to the effective date in connection with the business of professional wrestling, included but not limited to wrestler's legal name, nickname, ring name, likeness, personality, character, caricatures, signature, costumes, props, gimmicks, gestures, routines, and themes which are owned by wrestler or in which wrestler has any rights anywhere in the world, collectively the wrestler intellectual property, are described and identified on Exhibit A attached hereto and incorporated therein by reference. Wrestler hereby assigns to promoter the right during the term and thereafter as provided for in this agreement any sell-off period set forth in section 4.3, and promoter hereby accepts all worldwide rights, title, and interest in and to wrestlers' intellectual property, including but not limited to the rights to license, reproduce, manipulate, promote, expose, exploit, and otherwise use the wrestler intellectual property. Wrestler further acknowledges and agrees to that 1. Promoter shall own in perpetuity all footage as defined in section 2.1 of the agreement. 2. That the promoter shall have perpetual rights in the footage as set forth in section 2.2 of this agreement. And 3. That upon completion of the term, promoter shall have the continued right to use the wrestler intellectual property in connection with promoter's exploitation of the footage or any other copyrighted works that incorporates the wrestler intellectual property, which includes, by way of example, and not limited to, promoter's use in the marketing, publicity, advertising, distribution, licensing, and or broadcast of the footage or any such copyrighted work that incorporates the wrestler intellectual property. All right, so that is a lot to take in, right? So this should be simple. Basically, anything that's associated with the wrestler is signed over to the company for the duration of the contract. Okay. Now, anything created by WWE is owned by WWE, but WWE, in creation with the characters of all of these sorts of things, it is all intellectual property. So WWE owns the intellectual property of Roman Reigns. So that would be his theme music, his likeness, anything associated with him, such as logos like the Shield logo or the Roman Reigns logo or anything with a t-shirt on it. WWE owns everything. So he cannot use that if he leaves, but of course he can use his real name. He just cannot use the name Roman Reigns. Okay. So 3.2, except for the wrestler intellectual property specifically set forth on Exhibit A, any intellectual property rights, including but not limited to trademarks, service marks, copyrighted works, and or distinctive and identifying indicia, including legal name, ring name, nickname, likeness, personality, character, caricatures, signature, props, gestures, routines, themes, indices, dialogue, action, gags, costumes or parts of costumes, accessories, crowns, inventions, championship, title, or other belts, if applicable, and any other items of tangible or intangible property written, composed, submitted, added, improvised, created, or used by or associated with the wrestler's performance in the business of professional wrestling or sports entertainment, which were procured, owned, or created by promoter during the term of those which were procured, owned, or created by promoter prior to the term, and are described and identified on Exhibit B, attached hereto and incorporated herein by reference. Collectively, the promoter intellectual property shall belong to promoter in perpetuity, with promoter retaining all such ownership rights exclusively throughout the world, notwithstanding any termination of this agreement. This, of course, means that anything created by WWE is owned by WWE. So if the WWE created Undertaker, they own it. Undertaker cannot take it and go somewhere else. Even if he's not under contract anymore, he can't take the Undertaker likeness and everything and go somewhere else and do the gimmick again. Okay, so that's intellectual property. That is the WWE's intellectual properties as far as their contracts are concerned. Give me a minute to blow my nose. So, WWE has to protect their intellectual property rights or they can lose the actual intellectual property rights. That is why Vince McMahon sent out the letter to the wrestlers that were using Twitch and all these other sites, because that is essentially a cease and desist letter saying that you are violating the intellectual property of the WWE by using WWE name and likeness in third-party applications. So that's what that was. It was a cease and desist letter. It was just worded very strongly. But why would they do that? Why does WWE care if somebody wants to use Twitch or YouTube or something like that. Not just because it violates their intellectual property, but also when you consider that their intellectual property, it will be commingling on third-party applications with other intellectual properties for which they cannot control. Then you have other issues. For instance, WWE, if you are a wrestler from WWE and you're on Twitch, right? Anything that Twitch allows, when you support Twitch and you're actually supporting, in some cases, a competitor. For instance, Twitch also hosts AAA, Lucha Libre. They also host Impact Wrestling. Both have shows on Twitch. Also, there have been people who have been shot on Twitch. Okay, so you can be swatted on Twitch. So it's also a security issue. There have been people who have been their IP address, which is a computer thing, not intellectual property, but a different type of IP address, has been traced back to their homes. So when you think about this Sonya Deville incident, where somehow this guy managed to find where Sonya Deville lived, somebody could find, theoretically, where AJ Styles lived if they really wanted to know by looking up his IP address on his Twitch account. Okay, so yes, they can. Also, again, when I say third-party applications are involved in some things, for instance, Twitch might have, I think they just banned different naked girls or whatever. But there might also be other types of things where WWE does not want their intellectual property commingling with the intellectual property of other creators. Then you also have the situation where in some instances it is straight up competition. Where in like Cameo, like a lot of people will say, well, this is all just bullshit. It's cutting into the virtual meet and greets. Like, yes, absolutely. Cameo does cut into the virtual meet and greets. But, there is a lot of legalese involved in these situations. Now, some people have just simply changed their names on their Twitch channels and stuff like that. And that was pretty much it. And, maybe that'll be it. They just changed their name to something else. Just something that's not related to WWE. For instance, Kana-chan TV, which is Asuka's YouTube channel, has no reference. Well, she does reference WWE from time to time. So who knows? Maybe WWE actually owns that channel. And because I know WWE owns Up, Up, Down, Down. I'm pretty sure it does. Because they actually promote it. So anything that they promote, they pretty much own. They're not going to promote something if they don't own it. And that's also part of the concern that WWE wrestlers are promoting Twitch. And again, Twitch has things on it, and things can happen on Twitch for which WWE cannot control. So they don't want their intellectual property commingling with the intellectual properties of other people, or being involved in things to which they do not have control. And they cannot control what people do on Twitch. They can't control Twitch. Now they can enter a partnership with Twitch, in which WWE promotes Twitch and promotes the Twitch accounts of WWE product individuals. They're performers. And in doing so, they could, take a cut of the money or whatever the case may be. But there will also have to be other types of things that are involved. And so there's that. Yes, it is that maybe the performers making money and not cutting WWE in. That could be the case. But you can sublease your likeness or whatever by saying, hey, I'm going to have a contract with WWE and YouTube, or WWE and someone else. Now, there was a proliferation of Twitch accounts and YouTube accounts during the pandemic, where you started seeing a lot of performers just magically pop up having YouTube accounts. First it was Kana-chan TV and Up, Up, Down, Down. Then all of a sudden, Peyton Royce had a YouTube channel. Ruby Riott had a YouTube channel. Now Liv Morgan has a YouTube channel. So Kalisto has a YouTube channel. There's a lot of people who are YouTube channels, okay? Now, just because you have a YouTube channel, some of WWE might have ownership of some of them channels, which can help them curate the content, which also goes back to the concept of having your intellectual property rights commingling with things that you don't agree with. For instance, if a performer said something on Twitch, like a lot of people say, well, AJ Styles was talking about having COVID on Twitch. They're like, yeah, that's part of the problem. Okay, just because that's part of the issue. If they can't control or understand what people are saying, it could affect their brand. And that is the point of intellectual property rights, is that these are things that affect you and your brand, and your company and your brand. But it's the same thing for the individual. Just like an individual might not want their name, face, or whatever associated with certain things. They have a right to say, I don't want to be associated with this. This is all WWE is doing. It's saying we don't want to be associated with these particular outlets for various reasons. It could be competition, could be security, could be any number of reasons. But they have a right to say that, and it's 100% legal. And because the contracts do give WWE exclusive rights to names, likenesses, and all this sort of stuff, it is legal, and it has nothing to do with being an independent contractor. Because when you do things for YouTube, you're not working for YouTube, which makes it makes no sense. You don't work for YouTube, so you use the platform of YouTube. So it's also not just a WWE thing. DC Comics a couple of years ago, there was a boy. It was called Superman Boy. It was a young boy from Toronto who died. I believe he was shot, or he was not shot. He was starved by his grandparents, and somebody wanted to use the little boy wearing a Superman costume as a memorial for him. They contacted DC Entertainment, who owns the intellectual property of Superman, and asked them could they use the logo of Superman on the little boy's monument. DC said no. This is what DC said. I'm looking for it. Let me look for it. Hold on. I don't see where it says, but they declined. Oh, okay. Here it goes. For a variety of legal reasons, we are not able to accede to the request, nor many other incredibly worthy projects that come to our attention. This was from DC Comics or DC Entertainment Senior Vice President of Business and Legal Affairs, Amy Jenkins. Okay, they ended up reversing this, and they actually allowed the little boy to use the Superman intellectual property. And it was a couple of years later, but they rethought it. They allowed it to happen. But basically, there was also a thing where DC Comics just didn't want their IP involved with certain things. There's also any number of different intellectual property rights and different things like that. So if you recently, within the last couple of years, I was on a TV show. Okay, and while we were filming the TV show, there were legal people walking around, making sure there were no logos for anything. There, for instance, we had a bucket from the University of Michigan. They traded that bucket for a plain white bucket. It sounds petty, it sounds stupid, but they don't want to have to pay the University of Michigan to use their intellectual property. Okay, the logo of U of M, the big M with the big blue and the maize and blue M, is the intellectual property of the University of Michigan. They don't want to have to pay them for that. And they also don't want to promote that because you don't know what's happening. This is why you will often have bottles of water with no label, right? This is why when Stone Cold Steve Austin was throwing beers into the ring, they never said what brand of beer it was. It would always be Steve Weiser's, right? What is a Steve Weiser? It didn't exist. Well, it probably exists now, but it didn't exist then. It's about protecting intellectual property rights. This is and it's basically common sense. If they could cover up the logos on cars and different things like that, they probably would get away with it. But it's just basically WWE enforcing intellectual property rights. It's not that big of a deal. These guys are not slaves, as if people are trying to make it seem like online. Also, everybody that works there is an adult who signed a contract, and they all have lawyers. So ultimately, they knew what they were signing when they signed it. Now, the people who made the mistake of using their WWE name on their Twitch account or their YouTube channel or whatever will just have to go and change it. Now, and I think that might be it. I think if they just change their name to something else or something not related to WWE, then they'll be fine. And it's really that simple. I know that Paige changed her name on Twitch. And I think Mia Yim also changed her Twitch name. But most people just seem to, get over it. The fans are the ones who don't really understand and are overreacting. But thank you guys for listening. Like, share, and subscribe. I'll talk to you guys later. Peace.